1:04 p.m. And I'll note the members present. There's me, there's Thad, Judge Hall is here, Carol is here, Dr. Fradarelli is here, Dr. Andaya is here, Laurel is here with me, Mark is here, and Deirdre is here. So we have 1, 2, 3, 4, 5, 6, 7, 8, 9. So we have 9 people. That's enough for our quorum. And as usual, if you have someone with you in the room who's 18 or older, or anyone under 18 who has business or personal interest in any issue before us, please make that disclosure. Otherwise, I'll assume no one has anything to disclose. And Brandon, there's no one logged in from the public, is there?
No.
Oh, okay, great. So, so with no public testimony, I'll move on to the first item. This is an action item, and I want to explain it first. So, I introduced Sienna at the last meeting, and she was going to be acting as our attorney, and she's another attorney in my department and with my division specifically. But I'm actually going to need her to step in for me for a while because I'm going to be on maternity leave starting in July. So yeah, I need some help over here.
Congratulations.
Congratulations.
You know you have a sympathetic crowd in us.
I was gonna say we're really into pregnancy in this group.
We're down with babies.
I thought I would, see this whole birth certificate thing for myself.
But we are going to need an official Lion King-esque presentation of the infant.
Of the child afterward. Yeah.
Absolutely.
You can bring the baby, to show off at a meeting or something. You're gonna have to do that at the office anyway. It's fully expected.
Yeah, for Zoom will be from her.
Yeah, so so that's gonna happen. And my due date is July 20th, so I'm thinking sometime mid to late July I'll be gone. And I'm not sure exactly when I'm gonna be coming back yet, but I think it will be after the date that we anticipated having like a final draft done, which I think was October, the end of October was what we were thinking of. So I'm not sure if I'll be back by December, but definitely I'll still be out by the time the final draft is going to be due. So yeah, and also under the act that created our working group, it says that a representative from our department has to be should be serving as chair. So I'm not gonna no matter what, I'm not gonna step down as chair, but I think what I would like to do is have Sienna kind of cover for me. And like I said, I introduced her at the last meeting, and she's going to continue to shadow me until I leave. And after that, she'll be responsible for doing what I'm doing, which is, setting the meetings, creating the agenda, generally ensuring that we're all on track to meet the deadline. But even though, I'd ask her to fill those roles, I think I want to ask everyone to, help out and make sure that we're all meeting our deadlines and that we're all on track here. I see Jerry's here. Hi, Jerry.
Hi, I do apologize. I had computer difficulties and I've got Derek on the line. Derek, thank you very much.
No problem.
Okay.
Bye.
Bye. Thank you. My apologies.
No problem. So I was just letting everyone know that I'm going to be going on maternity leave in July. So I'm going to need someone to step in for me, and that's why I'm proposing my colleague Sienna at the AGs to step into the vice chair role and then become acting chair once I leave.
Congratulations.
Well, thank you. Yeah, so like I was saying, even though Sienna would be acting as chair, I would ask that everyone kind of help her out and make sure that, within your own pigs, we're progressing And, and make suggestions to her. I think if, for example, we think we need like an extra meeting or,
Mhm.
something that she can help facilitate, I think that would be really helpful. And I also think that once we appoint a pig to actually start working on a final draft, that pig is going to have a really important role in kind of leadership and making sure that we're progressing. So anyway, yeah, that's that was the proposal that I want to make. I'll let Sienna kind of introduce herself to you guys too.
Hi, everyone. I'm Sienna. I joined Lauren's department, the appellate department, in November of last year. So I think just about 6 months. Previously, I spent 5 years in private practice, and I clerked with Judge Bennett, so the Ninth Circuit judge for Hawaii, for a year. So that's my background, and I'm happy to be here. When I heard Lauren was doing this in the first instance, she was just talking about what she was doing, I was really interested in kind of what you all were like looking to accomplish. So I'm really happy to help her out and step into her role.
Yeah, I'm really glad someone in our division's been very interested.
Yeah. Are you sure?
We'll see.
So yeah, that's kind of my explanation of what I'm proposing going forward. So does anyone have questions or want to discuss? I really, I'd be happy to hear any thoughts or ideas on how else we can move forward.
Thank you for helping us and congratulations, Lauren. My only suggestion is that you would please remind us regularly now and every other time later about the internal deadlines you're wanting us to meet. Because I can tell you right now, I don't remember.
Okay. Point.
Yeah.
Yeah, let me
You can harass, well, I don't know if harass is the right word. Nag us, then maybe end up slightly. nice.
A friendly reminder
Yeah.
would be just fine. Much appreciated, please. Also, I have to know, Dr. Andaya, is that a baby Yoda in your background? It is, isn't it? It's a baby Yoda.
It is.
Yeah, okay, sorry.
He's got my back. That's my little like blankie. Yeah, he is. He's there.
Sorry, I just had to clear up my potential distraction there, so.
We respect all babies in this group.
Right.
Thank you.
that's a good point, Deirdre. So yeah, the next and that's kind of I did want to talk about this at the end of the meeting too, but yeah, the next deadline would be next month, actually May 24th is where we wanted to have all of the pigs come up, well, I think we called it a concept deadline. So we wanted to have the pigs kind of decide what the final contents of the reports are going to be. Not that everyone has to finish their draft report or their draft bill by that time, but I think we said people should be ready to come to the meeting and say this is what our pig is going to propose. Like if you're making big policy changes, this is what's going to be included. And I think maybe if it sounds like in some pigs there might be some like differences of opinion too on how to and like which I guess policy route to take. So maybe you could also share like what the different opinions are, and all of those could be included in the final report too.
Are you intending that the task, I'm assuming that, like, let's say there's a policy disagreement, either within a PIG or within the task force, yes or no on some particular point. I'm assuming at some point we're going to have to vote about what is going to be the task force's recommendation overall.
Yeah.
Okay, so my concern, just for planning purposes, and that there's no decision to be made on this right now, is that if there's a lot of those, we cannot do them all at once. Like those decisions cannot all be made in one meeting.
Yeah.
Because it basically what happens is on some of those points might be quite sophisticated. We got a lot of very knowledgeable people coming from different areas, touching on all these related questions. And it may take a while to have a discussion and get to the point where the task force could vote majority on what the task force's collective recommendation is going to be. So if we shouldn't leave all of those policy decisions to be made on one day, because it's just not going to work, is my prediction.
yeah, so
Yeah,
next month would be the time for everyone to present everything, I guess, and then we set deadlines in July for the, well, a July 19th deadline for the pigs to give their final reports, but I do, yeah, I think we're gonna have to, maybe before that, decide what's gonna go into the final report. June meeting is gonna be critical for that, and if like you say, we need more than one meeting, then we might have to do more than one meeting between the end of May and mid-July.
so what I would suggest then, and I don't know whether this would be appropriate as an action item or where each pig is in the process. But what I would suggest is that the concept deadline for next month, you need to tell us by exactly what day each pig has to get something in writing
Right,
to the rest of the task force, that it would present sort of overarching compared to the draft we were all working with, the one that Judge Hall had given us as a point of comparison. What are we planning on recommending, changes or not, recommendations about policy decisions that were discussed in the PIG, keep, don't keep, whatever, and lay those things out, even if you're not going to try to make decisions in May, because the very it just will not work if you try to have half a dozen policy decisions be made in a single meeting with a large group.
yeah.
That's what I think. So
That's
we need to
exactly-
front load it, like for example, our PIG has been talking about the difference between gestational surrogacy and genetic surrogacy, right? And between us, we have now, I believe, probably a consensus about where we think the task force should go. But we want to be able to have the task force know why we landed where we did, right? That kind of thing. And so I'm just concerned that it's just going to be too pushing the substantive conversation down the line is going to end up with, we're going to have a whole bunch of meetings in order to get all that done.
Yeah, that's a good point. So yeah, actually what I wrote down to bring up later is I think, so if May 24th is gonna be our concept deadline, a week ahead of time is when I'd want
You need to
everyone
post.
to put something in writing that everyone has enough time to review before the meeting so that we can come prepared. to
Right,
talk.
and that's part of the public documentation for the meeting, right?
Yeah, yeah.
Okay. So
Um,
for myself, what I would love to see my pig produce and the other ones is something not super long, because I don't think any of us have time to read a treatise. But, like at a summary level, explaining the conversations we had, what we've done, how, what our overall recommendations are, as a way to familiarize everybody where each pig has landed, right? That's what I'm thinking. If it was too long, then, anyway, so I would just suggest that, because taking a policy decision and making it into a bill is not an easy process.
Yeah,
There's going to be a lot of work involved with that.
yeah, thank you. Yeah, thanks for that. So, yeah, and again, this is something I wanted to maybe talk about before we adjourn for sure, but yeah, I think we want to have things in writing a week before the next meeting for sure. And then, yeah, Deirdre, like you said, if it looks like we're going to need more than one meeting to work out all the policy decisions and take votes, we should think about having, more than one meeting between May and July too.
Well, my hope is that each pig will be able to outline the policy decisions left to be made,
Yeah.
coming from each group, so that we'll have an idea of how much we're looking at, right?
Sure.
So my guess is in this group, there will be a few points that we need opportunity to have a full discussion on, but we're probably, we're not starting with a blank piece of paper, right? So that's what I would hope, so that at the May meeting, we'd be able to figure out how many policy decisions we're going to have to make time to make.
I saw that Lauren Kim joined earlier, so I don't know at what point you jumped in, Lauren, but so we're talking about my proposal to add my colleague Sienna to the task force, and it's because I'm going to be out on maternity leave in July, so I need someone to step in for me, and we're talking about how to make sure that we're all on track going forward too. So yeah, so Deirdre, those are good points about planning ahead. Does anyone else have discussion points or questions on the action item or anything related to that? Oh, I guess one thing I wanted to point out is that, so, when Siana's added, I'm not gonna be taken off, so it'll add to the amount of members we have, so we just have to be sure that we have quorum all the time. I think it'll push us from 8 necessary for a quorum to 9, which we've had so far, so I think we'll be okay, but I think we just need to keep that in mind. Like, if you can't make a meeting, please let Derek know so we can just make sure that we'll have quorum. Okay. Can I have it, does anyone want to make a motion on B1
So
to
moved.
approve? All right, thank you. All
Second.
right, thank you. So let's take a vote. Everyone in favor of having Siana added to the task force and appointed as vice chair, please raise your hand. Okay, I see. Let's just mark it. Lauren, Dad, Serge, Paul. Andrea, Laurel, Mark, Barry, and okay,
Lauren.
that's great. Thank you so much. So that passes with unanimity of the people who are here. And Brandon, again, I'm assuming no public attendees are here.
No.
All right, thank you. So no public testimony. All right, Siana, you're part of the task
Oh,
force now.
great.
Congratulations.
Thank you, everyone.
Good luck.
Okay, so moving on to the non-action items. The first C1A is a report from our permitted interaction group, the legal parentage group. So at the last meeting, well, I guess for the last 2 meetings, our PIG has been talking about expanding the eligibility to use the voluntary establishment of parentage process, and also the possibility of creating an uncontested parentage process. And the purpose of both of those changes would be to, I guess, allow for professed parents or people who want to be the parent of the child. And we're thinking specifically of like unmarried partners of the birthing mother to establish parentage, but we've talked about only wanting or like limiting the eligibility to situations where the birthing mother doesn't know who the genetic parent or who the other genetic parent of the child is, or yeah, and situations where there's not another presumed parent. So I just that's just like a recap of what we've been talking about. And at the last meeting, I think we're focusing more on the expansion of VEP process, and we had like a draft version of the bill which would include language that would allow for that, and it would only take a small change in the bill to allow for the courts to also create this uncontested parentage proceeding too. And at the last meeting, I know so far we haven't like taken a vote on whether we want to go with this proposal that we have. But I think everyone said they were, we would think about it a little bit more. And our PIG said that we would come back with some proposed forms that would show everyone how the uncontested parentage process would work in the courts, just kind of visualize it. And so those are the forms that we sent around earlier this week. Hopefully you've gotten to look at it. I know there were a lot of forms. The first, I think it's the first 3 or 4, the instructions and the affidavits of parent of the birthing parent and the intended parent. Those are the ones that Judge Hall created. Thank you so much, Judge Hall, for working on those. So those are kind of new. The rest of them are forms that the judiciary is already using for uncontested divorce proceedings, and maybe some paternity cases, I think.
There are current paternity forms.
So, yeah, we'd be using those forms, but in a new process where instead of like going to a hearing before the judge, a judge could review all the forms and sign off and say, this person is the parent. And if there's an agreement about custody and child support, the judge could also sign off on those at the same time. So, oh yeah, and they could also reject, like if they get all the forms and there's a problem with them, they could reject it. And Judge Hall, you can correct me if I'm wrong, but the intent would be like they might direct those parents to the regular process instead.
Well, actually, if they submit it as an uncontested, if there's any issue, we would set it for a hearing.
Okay.
And they can come explain, you know, whatever the issue is.
And so the instructions on the forms that we produced, they're obviously not in their final version, but we wanted to kind of demonstrate what the process might look like. And they also wouldn't be part of the bill that we recommend too, because it would be like like I said, the only change to the bill that would need to be made to allow for this process would just be to kind of say like the judiciary can do this, and then it would be up to the judiciary to adopt these forms. And I guess it'd be every circuit would have to decide whether they want to.
Yes, so to just clarify, currently, the way the statute reads, it requires us to have a hearing in every paternity case. So this just takes away the necessary of people actually coming to the courthouse. It would still be called a hearing, which is just the date set that the judge that's going to be reviewing the documents will be sitting down and reviewing everything.
Yeah, and we also would make it mandatory for the respondent, like whether it's the birth parent or the intended parent, but whoever is responding to the initiation of a petition, that they would have to sign something like acknowledging. We have a waiver, an appearance and waiver form, so they would have to sign it and say they understand, what this proceeding is. They received all the paperwork and they're waiving their right to have a hearing. So we couldn't, the judge would not sign off on anything if they didn't have that first.
And if any of you are familiar with our uncontested divorce process, one pretty significant difference is we will not allow defaults in this one. So it has to be by clear agreement between the parties.
But it's very helpful for those of us practicing in the area because, of course, as I pointed out in the past, people can give up their own birth child for adoption and not show up at any kind of hearing. They just sign the consent forms. But we make surrogates and people like that who are willingly consenting still show up for a hearing. So this is great.
So that was kind of the summary I wanted to give about what we've presented. Does anyone else from my PIG want to comment on the forms or what we talked about?
No, I think you got it pretty clear.
Yeah,
and just so everybody knows, these definitely would not be the final at this point, because of course the whole process would have to be cleared through judiciary chain of command. All the documents would have to be approved, and then each circuit can modify to fit their circuit.
Okay, so I'll ask if anyone has questions or if we want to discuss more, but I also wanted to again point out we haven't as a task force yet voted on whether we want to expand VEP and have this uncontested parentage proceeding, but that just from the past conversations we've had, it seems like people are generally in favor of exploring that. So that that's why we presented this.
I have one logistical question. Judge Hall, would we also have to ask judiciary to do rule amendments in order to implement this, or it's just the forms?
It would just be the forms once we have this. It's like 2-word change in the statute.
In the statute, right? Okay. Yeah, I've seen that happen before. Okay, well, that's just good to know, because I think it's easier to just skip right to the forms rather than have to go through a rule change as well after the statute is amended, knock on wood.
Yeah, so does anyone else have questions or? I see okay, so there's a question from a member of the public. I'll ask for public testimony at the end. But we'll finish discussion amongst the panel first. Jerry, do you have a comment or?
Yes, I believe Mark can go in details, but with regard to the use of the term professed parent, and it does appear on the it's referenced on the top page as far as the proposed forms. That term is not a term that's defined in the proposed Uniform Parentage Act. And I think rather than using the word professed parents, it's probably better we use the term intended parent, because that is defined in the proposed Uniform Parentage Act. And
I completely agree with you, Jerry.
thank you. Mark?
Yeah, for the forms. Okay, so
Unmute Mark.
I got it. Sorry. I think it comes to the larger discussion of, our PIG came up with the term presumed parent, and we do, CSEA has some concerns with that, how we defined it. It's a little broad and it could be open to some abuses. I don't know if we really considered who could utilize that if it was written the way it was. So I don't know if we want to discuss that in this group or in our PIG. But I think we did have some concerns with how professed parent is defined. I don't know if we can either tighten it up or whether maybe it's just better not to expand it out. I think the defined term, Jerry, what was the term you were referencing?
Intended.
So from
I'm sorry, intended parent.
Intended parent. I think that just references assisted reproduction, right? It's much it would be a small population that would expand it to. So I think that's part of the discussion, like how far are we comfortable expanding that out to?
Yeah, so the definition that our PIG was working with for professed parent is, you're right, Dre, that wasn't in the UPA. That was one that we kind of worked on in our group, right? And so we had defined professed parent as individual who's not the genetic parent, but who, along with agreement from the birthing parent, professes an intent to be legally bound as a parent of the child, where the identity of the possible genetic parent is unknown. And then we said it does not include genetic relatives of the birthing parent. So that last part, Mark, I think is what is the only thing we have now kind of that limits the definition of professed parent, and that was intended to prevent, like uncles and aunties or grandparents from being professed parents too. But yeah.
Right. I think when we came up with the term, we were kind of envisioning a situation where there's a birth mother and maybe her, as an example, her same sex partner, and they don't know who the father is. They don't know who the genetic parent is, but they're together and the partner wants to, parent this child. So I think that's the kind of situation we were looking at. But the way it's written, it would allow someone who is maybe just a friend of the birth parent to fit that definition. And I don't know if we considered that and whether that's something we would want to open it up to. There would really be no vetting no one to look over that. It's not going before a judge to determine, you know, is this in the best interest of the child? So I think that's where the hesitation comes from, is it does open it up to a broad group. So
Yeah, and we talked, we did talk about that, and we're saying that we're talking about how, you know, trying to limit to like a romantic partner or something like that would be really hard. Like there's no way to really have a good definition of that. So, yeah, so yeah, you're right. Anyway, the bigger issue about whether we want to expand, you know, eligibility to use either VEP or like this uncontested proceeding is still on the table, I think. And like I said, I think we're generally, like, it seemed like there was a general you know, openness to that, but yeah, but there are also definitely concerns that we haven't come up with. We haven't you know, come up with a final decision yet. And yeah, I think this is definitely something we have to talk about more within our PIG. And I think when we, you know, when we come up with like our concepts to present to the rest of the group, we might have to kind of like how we did a little bit earlier, like have a pros and cons list of like why, you know, keeping things status quo might have certain pros and cons, and expanding it might have certain pros and cons.
Yeah, and Lauren, I just want to, I think we had brought this up last time too, but I think it might be helpful for those of us who are not as grounded or embedded in kind of the nuts and bolts of this, to imagine that, like Mark brought up, like a case, not case study, but, you know, just like almost like in this situation, what it would look like for this person, what their options would be if we had VEP expanded or not, and if we had that additional kind of pathway that Judge Hall worked on. I think that would just help us visualize as well. And to acknowledge that, you know, it's not, we're not choosing one or the other. We can also choose both, right? To have expanded or whatever VEP amendment and have that additional judiciary pathway that Judge Hall had sent the documents for. Is that correct?
Yeah, definitely. Yeah, that's a good point. I think for not just for our PIG, but I guess for all the PIGs, it might help when you describe, you know, your policy proposals, to have like kind of case studies, or, you know, spell out the situations where certain things might apply. So yeah, that's a good point.
Lauren, sorry. I guess this is Laurel. I guess I thought we were using some of the guardrails or guidelines of Obergefell, and so I'm a little confused. I thought Obergefell was saying that basically we have to treat same gender marriages the same as opposite gender, which I completely understand and agree with. If we're expanding it to now say, which I think I hear what Mark's saying, pretty much anyone that's volunteering to be a parent now can be a parent, then yeah, I'm a little uncomfortable, because that could just mean anything. So I'm kind of confused, and I'm also a little concerned that I understand, you know, we have to follow what the Supreme Court said, clearly, but are we going beyond the bounds of that? I'm a little confused, sorry.
Yeah, so I think the intent is definitely to, like, the people that we had in mind in expanding eligibility were like same-sex unmarried couples.
Right.
So not necessarily the people who are, you know, the subject of the Supreme Court cases, but we do want to, you know, we're trying to make it equal, because unmarried opposite sex couples have the ability to, you know, have the male just sign on to the birth certificate.
Okay, but what allows that? Is that a law, or
What allows a unmarried male to sign a birth certificate? Is that your question?
Well, I understand if he's the genetic father, then he's a genetic father.
Well, actually, the current voluntary establishment of paternity, they don't have to prove that they're genetic.
Okay.
They're just stating essentially that they're the father, and they waive their right to a genetic test.
Okay. All right.
Yeah, so our intent is not to expand it to everybody, you know.
So that's
everybody who wants
Judge
to
Hall,
be a
that's
partner,
basically
or wants to
the
be a
challenge, though, which is because we allow it for opposite gender.
Right.
Okay. So I'm gonna ask, and I'm gonna push a little, because I think I said this last time. We have to do that? Is that because of child support? I mean, I understand we're trying to be same, excuse me, but
Do we have to have a voluntary establishment process, or do we have to
Yeah,
have it equal for both?
well, yeah, so I guess we're saying. No, I understand, I guess, why we have to have it for both, because we're already doing it for opposite gender couples, but I'm just wondering.
You
Have we,
have to have a voluntary process, because that's what allows for the federal funding.
right, so it is back, we're going, now it's because of child support, yeah, that's what I thought. So we're just stuck, right, basically, okay,
So yeah, so we do have to do the.
I'm sorry, I think I
Yeah,
asked this last time and it just.
Well, it's good to ask.
Yeah,
Not require, I mean, yeah, nothing's requiring us necessarily to expand it beyond what it is
Right,
now, but we
right,
do have to
right.
have.
Yeah, because I think I agree with Mark, I'm a little nervous about this. But I guess we're sort of stuck.
and
Okay.
I agree too. I'm a little concerned about the openness of the professed parent. I don't know if there's a way we could, like Mark said, narrow it somehow. I think then we'll have a really long definition though that could
Right.
run into even more problems.
Yeah.
It gets challenging because we don't require a romantic relationship of people entering into a civil union, do we?
No.
No, or a marriage, actually.
Right, or technically,
I know.
there are those who would say marriages are often not romantic.
You don't actually have to. In the eyes of the state, they don't ask you anything about your emotional state.
Right.
Laurel, I want to thank you actually for repeating that question because I thought it was really helpful. So let me see if I've got it, because we're not making any decisions today, but what I understand is because of the federal funding allowing for a voluntary establishment of paternity, we must do it for a father who steps forward to say that he's the father. Okay, and that's my understanding. So then the policy question that this PIG is going to present to the task force at some point is whether to expand that in some way. And it seems to me that although we might be amenable to the idea of expanding it, how to go about doing it becomes the challenge. Did I get it? Is that it?
Yes. Yeah.
Okay.
I think
Okay.
it's also, is it, Judge Hall, let me know if you disagree. I think it's also, there's kind of a general policy presumption that a child is better having two parents than one. If there's a second person willing, able, I mean, we see that in step parent adoption statutes. We see that in a bunch of places as a general policy. When there's a second person willing, able, and desiring to be a parent to the child, the policy is generally
Favor it,
favors
right.
making that possible
That's true.
And I
in,
think
in the
Mark-
in the best interest of the child.
I think Mark and Jerry have also clarified, like, it doesn't matter, for our federal funding, as long as parentage is established, either through VEP or through the judiciary or like on a birth certificate, just the establishment of parentage, those statistics are what matters for
Yeah.
federal funding, right?
Okay. Okay. That's helpful. Thank you.
May I say something, Lauren? So I'd like to clarify. You are correct as far as federal funding, we need to establish parentage. And right now, there are two ways of doing it. Judicially, you can bring an action in which the court addresses that issue. And the other way is the administrative, I call it administrative because we do not go through the court, but it happens at the medical centers, it happens at the Department of Health, it happens with the midwives. But again, the forms are very, and the directions are address a situation where you have a mother and a father for this child. That is what is recognized. And that's why even though you say it can be any male, it's not just any male. It is, it's assumed that the person who's going to take on the responsibility of being the father of the child is the genetic or biological parent of the child. It is very clear she gave birth. So by giving birth, the court presumes she is the parent, the legal parent of the child. And I think it states in 584, she is the legal parent by giving birth. It's the other parent that we're addressing. And I was looking through the proposed uniform parentage law. We really have to be careful because as far as what is there, that there is a section that says once you have an adjudication of parentage and through the VEP process, you have a 2-year period in which to try to negate your parentage. But after that, it's closed. You are the parent. So to the extent that there was an accommodation, that is someone who is not the biological parent, thinking that there are no ramifications, that they would not be responsible for supporting the child, we would have to change our forms. If this parentage law as proposed is passed, we would have to give notice to make sure that the parent who is not the birthing mother understands that there is only a short time period in which they can decide to change their mind because they are not truly the biological or genetic parent of the child.
I'll be honest, I don't know if I would want to change your forms to say that, because then we'll have a lot of people with buyer's remorse if the relationship doesn't work out in a couple of years. And it's not the situation we have now where it's on the forms, I don't believe. And it's not as big of an issue, but I think if we point it out to people, it's going to become an issue.
I think a good example of scenario, Judge Hall, remind me if you, or let me know if you disagree, is the woman giving birth is no longer with the guy who she conceived the child with. She is with a new partner. At that moment, she's convinced that partner is going to be her partner for life. They agree to put him down as the genetic, as the second legal parent of the child, and he therefore becomes bound. I don't know if it's clear that they understand that, you know, if the relationship breaks up a year later, that nothing's going to change, but that's the way it works now.
That is correct. And then I have a situation where the child is 7 years old, and the man who at the medical center acknowledged being the parent of the child and subsequently signed all the forms so that his name appears on the child's birth certificate, has buyer's remorse. He really no longer is with the mother. He knows he's not the biological parent, and he's reached out to the biological parent saying, hey, you're the biological parent. I'm willing to step aside. The child is 7 years old. And so now the biological parent is saying, I didn't know this. But now that I know this, I have no other children. And if this is my only child, I want to be the child's father. So because it's already been done, the agency has a difficulty in assisting in disestablishing paternity than establishing it.
And honestly, that situation, the agency should not be involved at all. They need to go to court and they need to deal with that, because that happens more often than most people would think.
Yeah.
And the question becomes, you know, I may not want to let that guy who's held himself out to be that child's father for 7 years off the hook.
Right.
Because that's harming the child.
Yeah, good.
Yes, except in this case, there was no contact with the child. In fact, the person who signed the VEP form subsequently was incarcerated and has been incarcerated for many years. So there's been no bond between he and the child. He just wants to start fresh. He's saying, hey, I can't support the child. This is not my child. I'm no longer in a relationship with mother. And it's a 7-year-old child.
Yeah,
so I think we do have to give notice. Pardon?
The agency should not get involved with that.
No, the agency is not involved, but I'm telling you, these are the kinds of cases
exactly
that are coming.
But you just go to, I mean, when you get something really complicated like that, then going to court is the answer, right? And you let the judge look at all the facts, and so family court has sufficient discretion to evaluate all the facts as may differ from case to case, right?
That's the key difference, isn't it, Judge Hall? If you have an alternative person who is arguing to be established as the parent, then you go to court, the court makes the decision whether or not it makes sense. But when somebody's trying to get off the hook and there's no alternative, I think that's when it's a lot less likely that they're going to be allowed to get off the hook.
Right.
And just to clarify, some of the, I think the changes that we were, or some of the language we're proposing in, you know, both the expansion of the EP and these forms would require that both, you know, both the intended parent and the birthing parent say, you know, attest to the fact that there's no other known genetic parent. So we're trying to prevent situations like that from happening. I mean, obviously people can lie, but yeah, like the intent is to lessen the occurrence of those situations too.
Excuse me, and also, if you use the term intended parent and you then expand the group that can become parents, they are not the they're not the birthing parent, they're not the genetic parent, but they are interested in becoming the legal parent of the child. They also have to be informed that there are not only benefits, but their responsibilities, and that there is a time frame. Everyone should look to the proposed laws, but there are timeframes in which you can try to set it aside. After that period, although right now we're quite flexible, the child is much older. If there's no bonding, the court can consider those factors. But I think under the proposed Uniform Parentage Act, there may not be that option. And so I think notice is best so that everyone is on the same playing field in terms of what they're doing, in terms of in acknowledging paternity or becoming a parent, a legal parent of the child.
Well, I think it would be something we would discuss later because we're not making any decisions today. We'd have to first decide if we were going to expand. It's not intended parent under the draft partial bill that we have is related to assisted reproduction. It's not related to the professed parent concept that the PIG is discussing. I personally see no need for additional notice. The law itself is notice for all purposes.
I mean, that's up to the department if they want to change the forms to do additional notice. It's a call that I think the department has to make, but it's not a requirement necessarily for our task force to make that decision, and it wouldn't affect any potential statute.
It is interesting, just as a side note, that when we're doing an adoption finalization, for instance, part of the standard script is requiring the parties to acknowledge that in the, as I like to say in the hearings, in the unlikely event of the dissolution of your marriage, that there will be issues like child support, child custody, time sharing, and the like that would have to be resolved. So in the context of an adoption, we force people to acknowledge that, hey, by the way, this obligation will outlast your relationship if your relationship doesn't survive.
Yeah, that's a good point.
So yeah, understanding that we're not making a decision today on the expansion of the EP or, you know, the adoption of a uncontested proceeding. And does anyone have any questions or other concerns about what we've, you know, the forms that we put forth, or does anyone have any more comments on just the general topic of PEP and professed parentage?
I would love to see if your PIG can try to define it. Because I think we're gonna and I think Thaddeus's idea to have like hypothetical scenarios is super helpful. That's like the entire way to figure out how this actually works. Because for myself, I'm certainly amenable to trying to make the law as equal for same-sex couples as it is possible to be given the biological realities. But I am also concerned about like what policy problem is this actually looking to address, and how can the statute be written to address that and nothing else, right? So I would love to have another attempt at this, you know, from the PIG.
Deirdre, you introduced us to a useful term in our PIG, I believe. What was it? Soap opera scenarios?
Soap opera scenarios, yeah. We used
think
it
of-
1,000 times when I worked on the Marriage Equality Act more than 10 years ago. We would test how the bill would work by running through soap opera scenarios. So it was like, you know, the woman's married to a man and then she has an affair with another man and then they get divorced and then she wants to marry her same-sex partner who's already in a reciprocal beneficiary relationship with somebody else. And then how do we make all those legal relationships go in the right order? And like it turned out that called them soap opera scenarios because they all sounded horribly dramatic, you know, but like there's a provision in the bill that makes it so you don't have to terminate your civil union in order to get married to the same person. Because you're not divorcing them, you're just, you know, quote, upgrading the status of the thing. And we figured out that if you require them to end the civil union first, the scenario was this loving couple who's been together for 20 years and has been in the civil union for 7 and now wants to get married, they have to terminate their civil union. They terminate on a Monday. They're supposed to get married that Saturday. Wednesday, one of them is killed by a truck.
Right, yeah.
Right. And so we made it so that the civil union ends when the marriage begins at that moment. And that's the kind of scenarios that really help. Right. And but they all sound horrible.
Yeah.
So yeah, soap opera scenarios. I'm all for it because it really helps. Otherwise, these legal concepts get squishy and you can't quite figure out, you know. But I remember having that exercise be extremely helpful when we worked on marriage equality. So for myself, I'm open-minded to whatever the law can do to, you know, inch all of this toward as equal as it can be, but I am concerned about what policy problem is it actually trying to solve, not a hypothetical problem, but a real one, right?
Yeah.
And also to not have the unintended consequence of being more broad than the consensus of this group would actually seek. And anyway, so those are the questions that I'm hoping that the PIG can give us a little more guidance on.
But I will say those soap opera scenarios, it's amazing how they come up.
Yeah, they
It really,
do.
it really is.
I'm sure you've seen a lot of
those are
them.
the people who come to us, you know. Oh, my husband and I have been split up for 5 years and now I'm 39 years old and I want to have a baby, but he's a presumed. I mean, it's crazy.
Mhm. Yeah. Anyway,
Yeah, so thank you for that. Yeah, so I think that will be something that we keep in mind when we come back with our concepts to present to everybody. Any other comments? Questions? Brandon, I saw that there might have been somebody in the
Who wanted
public
to-
watching. Is there any one there?
Yes, and they asked a question in the comments.
Okay. Can you ask, can you have them join? And I can
To
ask
be
them.
able to speak on mic?
Yes.
Oh, yeah,
I believe it's Ashley Miracle.
yes.
Hi, Ashley, did you have any public testimony that you wanted to present on this item? We were talking about an update from our legal parentage permitted action group.
Yeah, I just wanted to introduce myself and then I did have a question. So I'm Ashley Morocco. I'm a 4-time surrogate. And I also own a surrogacy agency. I was born and raised in Hawaii and then recently returned back and relocated back to Hawaii. So I'm definitely here to just support, listen in the background. But I did have a question about when you guys were discussing the documents, and obviously I'm not a lawyer. But are you guys working, is that those documents would be filled pre-birth, or are you guys going to continue to do the post-birth for surrogacy?
So if I could probably jump in there and then Carol, you can too. The documents we were talking about is post-birth, but the draft that we're working on does allow for pre-birth orders also.
Okay, thank you so much.
Okay, thank you. I assume there's no other members of the public want to testify. Brandon, no one there?
Nope, no one else.
Okay, great. All right, so let's move on to the birth heritage PIG and see. I don't know which one of you wants to give any updates, but
I think Laurel's got us on this, right, Laurel?
Well, we weren't able to meet. I think it was spring break and children graduating and trying to get to college, and so we weren't able to meet. What I had proposed to the group just through email was that we start with what the uniform law commission had sent us with regard to donor identity. But I know we kind of talked about it briefly, I think at our second meeting, and I have some notes. I have to admit, I miscalculated when our report was due, and I'm traveling the next 2 weeks. So May 17th could get interesting. But I think our concept, well, in my mind, it's fairly clearly defined if we use what the Uniform Law Commission sent us. But I think Carol has mentioned whether there's consensus or not, I'm not quite sure. And so I don't know if we should just give a report of our notes so far, which I think I've done, but we haven't talked about them really in the group. But Carol, maybe you could jump in.
Yeah, we can make a point of scheduling another meeting, assuming you have availability before you go. And I think we'll present what we talked about. I don't think we actually have to make the specific decision. We can present the issue for the committee to decide, and maybe some suggested proposals for how we would want to see things work, whichever way it went. But we'll figure something out to
So I leave Monday night. So
oh well.
And Jeff is not here, who hosts us. So I don't know if you want to meet we can try to schedule a meeting, and I'll be on the East Coast. Or I can just quickly put together something before I leave, and as far as a quote, because if it's a concept, I think our pig knows what the concepts are. I don't think we've talked about it in a larger group. Is Carol, you think, and I don't know if Lauren and Dr. Andaya want to jump in. But
can I ask for clarification? When you say the stuff the Uniform Laws Commission sent, was that the new provisions?
Yeah.
Okay.
Yes, Judge. Yeah, the newer ones. That's where we were kind of.
And so I think you might have talked about it last time, but were you generally okay with those?
Well, I think it's definitely a shift from the prior draft that was presented to the legislature last year. I think Carol made a good point that actually part of the challenge for using this in Hawaii is that we don't really have any donor banks in Hawaii. Is that right, Carol?
Well, yeah, I think I made the point that to the extent, you and I, as I think is well known, have slightly different perspectives on all this, but it wasn't going to have a significant impact in the state of Hawaii if it were a law that restricted sperm banks in the state of Hawaii or donor banks in the state of Hawaii, because there's not a lot of that going on here. So, for some of us, that might have been the good news. for some of us, it might have been the not so good news, and it might suggest there's other things that you'd want to put into a statute that would give you some comfort along the lines of your concerns. So it was just something to take into account.
Right. So,
I think general kind of, as people know, the general difference is the level of comfort with the concept of anonymous donors within the PIG is different. I have 2 children from anonymous donors, so obviously my comfort is higher. But Laurel has a very valuable perspective as an adoptee herself, which makes her voice important as well.
So I guess I can get some notes together. I guess what I can tell the group is I can get some notes together and circulate them to our PIG, which would be the consolidation of our 2 meetings, basically, the reports of the notes. And then we can try to schedule a meeting. We'll see, I guess.
We'll work it out. We can deal with East Coast time. It won't be the first time.
Yeah. Well, Jeff, I don't know. He's the host. He's the Zoom host. So we'll check with him.
Can you guys, I'm sorry, can you guys resend the document you're talking about? I must have lost it in my email. I just would like to see what it is that you're considering.
And can I also ask in your concept, maybe since there is 2 pretty differing positions, if you guys could kind of share some of the explanation as for each position, and that might help when the bigger group has a vote, a better understanding of each side.
Okay. Yeah, I think the draft Deidre was sent by the AG's office, but I mean, I don't know, Lauren, do you want me to do it? Or,
Everything that we've circulated should be on
Or
our
posted
our
on the website, yeah.
too.
Oh, okay.
yeah, I mean, it's an official uniform law draft.
Yeah, I don't remember which.
Oh, I thought it was something else because you sent the uniform law, sent it to us as opposed to something we could just find online. I didn't understand.
I think it was sent, not for this meeting though. I think it was in another. in a
Yeah, it was
previous
sent,
one.
Okay, I will let you know, meaning Lauren, if I can't find it.
Okay.
So, yeah.
Should be on our, everything that we've circulated should be publicly posted on our website too. Our webpage. Okay. All right, anything else from the Birth Heritage Committed Interaction Group? Brandon, any public testifiers here? I assume not.
Nope.
Okay, thank you. All right, so I will move on to the assisted reproduction and surrogacy PIG. Yeah, I'm not sure who wants to speak up for them, but the floor is yours.
Carol, do you want to go?
I was gonna say, Deirdre, are you looking at me?
Okay, I'll do it. We've met, we met last week. We got a plan to meet again next week. Mihoko has been very busy with the close of legislative session. But Carol, Dr. Frederelli, and Sean and I met earlier this week. We've made quite a bit of progress. I mean, it's quite a lot there and there's a lot to think about. But I think we made some progress so far. We seem to be circling around the idea of suggesting some additional definitions that would help the surrogacy and assisted reproduction portions work a little better or make them a little clearer. Some edits for clarity. And we did have a debate where we talked ourselves out of genetic surrogacy regulations and then talked ourselves back into it. And I'm very comfortable with where we landed right now. So this isn't an official decision, but this is my understanding of where we've gotten so far. And we haven't had the chance to talk to Mihoko about this, at least I haven't, was that the general theory that although both the doctor and attorney practitioners in the field do not favor genetic surrogacy, that it would be better to regulate it than to leave it unregulated. So it's basically pure pragmatics. I was, Carol had really done some good thinking about this and she definitely solidly persuaded me on that. So we don't know how much of a problem it is. The way it's structured now is you have like a whole bunch of stuff you have to do for a surrogacy agreement and then for a gestational surrogacy agreement where the woman carrying the pregnancy has no genetic relationship to the child, right? And then if you're going to do a genetic surrogacy where it is genetically her child, it's a whole whole pile of additional requirements on top of that. That's the basic structure. So that's where we got another meeting scheduled next week with Mihoko should be able to join us. And we're working with a draft section of the bill as our way to discuss things. And it can get pretty difficult, some of the sections, right? Trying to figure out exactly how it's going to work. But we have made some progress. Did I miss anything, Carol, Dr. Frederelli?
I don't think so. We kind of came full circle on that issue, Judge Hall. We came back around to.
Yeah, we
had to
debated
explore
it
all
and then we debated it
alternatives
around
before
again. Yeah.
We looked at the morass in all the other states and all the different ways that it's handled and how crazy it is and how much of the Wild West it is and all the places that just leave it silent and came around to the conclusion that it was hard to see that as a better alternative. And the only other thing I would say is we have talked about the possibility, Judge Hall, of we'd have to make sure obviously it complied with all applicable rules, but whether there was a way to have you join us at some point when we got towards the end and we'd gone through everything just to discuss changes, because we don't want to undo something that there was a really good reason for the way it was that we just didn't happen to think of it. I don't know if you'd have to join our PIG or if we would be able to bring you in without that, but we were thinking before we presented to the larger group, it might be valuable to get your input because we don't want to undo good work because we simply just didn't think of what the logic was behind something.
To be completely honest, because I'm no expert when it comes to assisted reproduction or surrogacy, that language was straight from the UPA, except for some few things, Carol, that you had suggested way back when.
Well, those are probably all wrong. We're going to undo all those. Okay. All right.
So,
We've been working on like, because we appreciate the edits for, to make it more inclusive, right? So you're not saying, you know, just the woman, like this, the individual or the birthing parent. But then we wound up with a problem with multiple individuals who are different people in the same sentences. And we were trying to find a way to, anyway, we were trying to find a way to make line edits that would make that clearer, right?
Which individual we're talking about?
There's just too many individuals in this paragraph, right? And so, in any case, we've been trying to balance all of that. And anyway, we have made some progress with it. And I think that I have found it particularly helpful to look at the commentary from the most recent UPA. It's been very helpful, and to do a side-by-side comparison with the draft bill with the UPA. And that far and away, that's been the best time I've spent on this project for for myself. Has been just to look back and forth and see where the differences are, and to see what those differences might mean. We did run across a couple of, policy debates. I don't see them as huge if the task force agrees with us about genetic surrogacy. The other possible policy things, which struck me as smaller issues, is like, for example, in its current form, the draft would mandate that surrogacy agreements be confidential. And we thought, why does it have to be mandatory? Why can't it be voluntary? Meaning they can make it confidential if they want to, right? I mean, that kind of thing. That didn't really seem super controversial. There's also a difference between notarizing some of the important documents involved with surrogacy versus just witnessing them, things like that. So, and to me, those are, they're policy questions for sure, but they're smaller than the big policy questions and more like implementation details. So in any case, we're looking at those kind of things. So I think we'll continue to make progress between now and the May meeting. And I thank you, Lauren, for clarifying the deadline. So.
Yeah, and I'm not sure, like, I guess you haven't made a decision about whether you want Judge Hall on your page or not, but I think if she does, if you do want her to join, I think we have to do that at a meeting.
Yeah, you have
So
to.
we have to get notice to put that on the agenda.
She can be on the drafting one.
Yeah, and
Yeah, and it may not be necessary. I know we're allowed to reach out one-on-one if we have a question too, so.
Well, I mean, the fact that she clarified the source of that language today kind of
Yes.
answers, we just were concerned that we were like talking ourselves into an edit that somebody thought about already and had a good reason not to, right? So.
and if I
Somebody
can
did.
Somebody did at the uniform law, apparently. So.
And with the issue of the confidentiality, just because of the judiciary computer system with this electronic filing thing that we have, for the system itself, it would probably be better if there's a determination if you want it sealed or not sealed, because then the case itself will be sealed as when a case type is created. All
Right.
cases under that case type can be sealed. Otherwise, all cases under that case type would be open, and then we'd have to go in and seal.
Oh,
each
I see.
individual.
Okay.
Yeah.
No,
Okay,
we
yeah, I
want it, we
think-
want it sealed.
We want it sealed, right? Like
100%.
like a lot of family court proceedings already are, right? Okay, so
Yes.
my understanding is that actually is two separate provisions, Judge. One of them is like whether the surrogacy agreement itself, the contract must provide that the contract is confidential. And then there's a separate section that determines the fact that the proceeding itself is sealed from the start. That was my understanding. Right.
As a practical matter, I'm not real concerned about that because they all say confidential unless the parties agree otherwise. So they always have the option of electing to be more open with it. And it's a
Right.
standard provision. So that's not one I
Yeah,
would
I
sweat too
read the
much.
statute as requiring something that I thought should be left up to the parties. So maybe we just need to fiddle with that statutory provision. But anyway, those are the kind of things that I think will be left open for discussion. The big question was what to do about genetic surrogacy. And the question is either ban it, which despite the group's general understanding of why it could be often problematic, nobody wanted to ban it, regulate it, or say nothing. We landed on the middle as the recommended course of action. So that was the
But-
biggest decision.
Just so
Yeah.
people know, because there
Yeah.
are outlier cases, same-sex couples whose sisters already had 5 children, has no interest in having other children, is willing to do a traditional surrogacy for her brother or something, where you say, okay, well, I'm generally not at all in favor, but with the right safeguards in that case, it might actually make sense. So,
Sorry, can I
Yeah,
ask this one?
sure.
So we have Hanai covered, Deidre? I mean, because Hanai is oftentimes genetic. Because I remember when we were talking about this, we thought,
Well, I was assuming perhaps incorrectly, so anybody can jump in and correct me with the information on the ground, but I was assuming a Hanai style adoption would be handled under other provisions. The stuff that we're dealing with is with the existence of science,
okay,
right? Yeah, it's for artificial insemination, you know, IVF and surrogacy agreements that involve those things. It's
Okay.
all the tech side.
okay. That's the
Yeah.
one thing I'd want Judge Hall to look at to make sure we're not messing with Hanai. Sorry, Judge, I just want to make sure. Okay,
No, we definitely cannot affect the Hanai provisions that's very unique to Hawaii and we
Yeah.
need to keep that.
okay, all right, thank you.
And then maybe, I think maybe you guys mentioned this in another meeting, but there's no other state that adopted the genetic surrogacy provision yet, right?
Well, our research is all over the place, right? The UPA commentary itself says that the states who adopted its version of the gestational surrogacy law have declined to adopt genetic. However, Carol has also done research that indicates that there are states that regulate genetic surrogacy. Is that accurate,
Basi-
Carol?
Yeah, basically where
Yeah.
it comes out is there are a lot of states where it's allowed because it's not prohibited. There are other states where it's allowed but not prohibited, but there are other restrictions that are imposed on it. Sometimes, for instance, adoption type laws get applied by the judges without express statutory authority.
Not the
Um,
language.
There are states where it's clear, and then there are a few states that have just completely outlawed it and said
Banned it,
it can't be done. So it's permitted by default in the vast majority of states. It was literally looking at that list and all the different scenarios in which it could or couldn't be done. And in some cases, it literally will depend what judge you get. Where we just kind of came down to, you know what, we're back to thinking that leaving it open is not a good solution. We gotta provide, if somebody wants to do it, we need to provide guardrails.
Right. That was basically where we landed, is that even though, you know, what Dr. Fraterelli explained to us, you know, that the doctors who work in this area really didn't want to do it. And Carol explained that the
Neither do
lawyers
I.
don't want to do it either, you know, and so like the
Rare
people who work
cases.
in the field find it to be basically be a disfavored practice for reasons I think we all understand. However, we also were all fairly easily to come up with a scenario in which, you know what, hey, maybe it works for this family, right? And so, you know, and that to me personally, I did not want to leave it unregulated, right? The potential harm of leaving it unregulated seemed to me to be the greater risk than proposing something along the lines of the draft bill that Judge Hall had already shared with our group, which is essentially you have you have to meet all the procedural requirements for a gestational surrogacy agreement, and then on top of that, you have additional requirements for a genetic surrogacy agreement. And one of the most significant differences is that the birthing parent has up to 72 hours after the birth. It's her child, right?
Yeah,
Her
I was gonna say
genetic
the
child.
bottom line
Yeah.
is unlike a gestational surrogacy, the states that do have laws recognize the right of the mother to the birthing mother and also the genetic mother in that case to
Right.
change her mind.
Right.
And then you end up in a co-parenting situation.
Right. So, and that hypothetical would probably be enough to make people decide against that idea.
That's kind of the hope.
Right, yeah, in any case, but you can see why there would be reasons for that, right? So, and anyway, I'm not claiming at all that it's easy, but having thought about it now several times, and then especially studying the two different versions of the law side by side, I found very helpful. That's sort of where I landed. I felt like there was danger in leaving it unregulated. My personal preference would be to see it regulated in a way, you know, if the state makes something burdensome, it is a functional way to dissuade people from doing it, even though you're not banning it.
Yeah.
Right.
Well, thanks for that explanation. I'm really interested to see the concepts that are proposed. I think it'll be really, yeah, this has been like something I didn't know anything about. So it's been really interesting learning all about it from you guys. Okay, anyone else with questions for the?
Oh, one last thing. We decided we had to define embryo, and we had Dr. Fraterelli write it for us.
And we defined record.
And we defined
Based on
record by
Deirdre's
pulling it out of
research.
other laws. I found other Hawaii laws that use the uniform law definition of record. But that part was easier, but then, yeah, I've said, Dr. Frederelli gets to tell us what the legal definition of embryo should be. So
Um,
so that's it for us, I think.
okay, anyone else have questions for them? Comments? Brandon, I assume no one's there from the public?
Nope.
Okay, all right, so yeah, before we adjourn, we already talked about this, I guess, earlier, but I wanted to talk about the upcoming deadlines. So yeah, just to remind everyone that at the next meeting, which is gonna be May 24th, we decided that we're gonna, present at least what each PIG proposes to have in the final content of their report. Again, you don't need to have your draft language and your draft report finalized by then, but tell us what you think you want to include, and highlight the policy decisions you're making. If there's still policy disagreements within the group, definitely note those. I think we should have, every PIG should have something in writing ready to circulate to the rest of the PIGs the week beforehand. So I'm actually, I try to get the agenda posted as early on Friday as I can. So if you could do it by
Friday is at 17.
Okay, the 17th, if you could send them by the morning of the 17th, that would be ideal.
You got lawyers on this call. You want 11:59 or 10 a.m.? 10 a.m.
Yeah.
I'm pretty sure I heard 12:32 p.m.
I was just thinking, because I would love it if when you circulate those, they're all together on one email rather than
Okay.
separated. So I would love it if we could agree between us, please, to get them all to Lauren by 10 a.m. on the 17th, so
Sure.
she can put them together and circulate them all together in one email
Yeah.
with the agenda.
And then, yeah, I think what we've talked about, like things that would be helpful to include in the reports would be like descriptions of how different scenarios where we think these policies are going to work in practice, like what situations we're trying to address. That'd be helpful. So yeah, and then after that, we have our next meeting after that scheduled, I think.
Yeah, we have one in June.
28th.
June 28th.
Okay. Yeah, so if after we get those concepts together, it looks like, we're gonna need more than one meeting to hash everything out. We'll talk about that at the May meeting, and we'll see whether we have to schedule something else in addition to the current June meeting.
That would be helpful, because then we also could divide up which policy discussions are going to be discussed on which day, maybe organized by the PIG divisions or something like that. We should bet on there's going to be at least a second meeting, if not a third. Some of these conversations are not particularly easy to figure out what to do. And then, of course, that's before you actually try to make it into a statute.
Okay, well, I think that that's what I wanted to mention before we close. Does anyone else have questions or anything else they want to bring up before we adjourn today? Okay, all right, so I will adjourn. It's 2:23 p.m. and yeah, meeting's over. Thank you, everyone.
Bye, everybody. Thank you.
Thank you so much.
Thank you.
Thank
Bye-bye.
you. Bye.